Test, test, testing. Can you guys hear me now? Somebody comment that you can hear me.
There we go.
We're on the computer audio. I'm sure it's terrible. That's fine. The maybe it's
expensive thing you mentioned.
The expensive stuff isn't working. The cheap shit is.
Surprise.
Let me start this thing over for a third time.
Third time's the charm. Let's go.
My name is Matt Mulholland. That's Ben Brown. PA was in Georgia. Now he's in Texas. And we're going to talk about why he made that move and the differences, because Georgia is what I would call a low leverage state and Texas is a high leverage state. I'll explain that in a minute. This is the Listen to This Bull Show. If you've never seen this show before, we talk about bullshit in the insurance world. And we do it live so that you can ask us questions live. So feel free to put something in the commentary to ask us questions. Now, before we get started, I want to say I really appreciate all the support. I know I haven't done a podcast in like a month. I've probably had about 72 hours at home in the last month and a half. Expo season is crazy and it's almost over. But luckily we were able to squeeze this one in because I happen to be able to get out to Texas before the next event enough to be able to do this live with Ben, and in person is so much better anyway. So now we can get started. Should I hit the button again is the real question.
Absolutely.
I'm going to hit the button again.
Absolutely.
I love hitting the button.
Hit it twice.
I love live shows.
Me too. First one, but I love it.
All right. I mean, the benefit of live is I don't have to edit it, but now I might have to because we had an issue. The button does rule. Thank you, Ars. You're absolutely right. The button rules. Thank you. It's good to see you guys again. It's been so long. There's Hank. Hank's your partner, isn't he?
No.
Tom Crow.
Tom Crow and Chase Hinton.
Oh, I don't know if I've met him.
Erica,
nice to see you guys. Okay, so the idea behind low leverage and high leverage states, for the audience purpose, I consider a state that has really crappy consumer protection laws revolving around insurance to be a low leverage state.
Mm-hmm.
The policyholder really just doesn't have any authority because there's nothing to help them against the insurance company.
Correct.
Low leverage state are the harder states to work in.
Georgia being prime among them.
Georgia, I would argue, is the worst.
It is, absolutely. I think it's beyond dispute.
I would say there's a few that are close. Wisconsin comes to mind.
Mm-hmm.
That's a rough one. But I would argue Georgia's the worst. And I might even fight you on it. And then there's the high leverage states. Those are the states where the consumer protection laws are so glorious that you have the ability to push back against a carrier with some authority behind you. The Department of Insurance, the laws that are there, potentially being able to get bad faith, trouble damages, punitive damages, interest, all these things. Texas, high leverage state.
Absolutely.
And then there's everything in between.
Yes.
And most states fall in between somewhere in there. So you've done probably the lowest leverage state.
Yes. And
it could be argued that Texas, at least at this moment in time, is the highest leverage state.
At least in the top three.
Yes. It's definitely in the top three. And the other ones would be
probably California, at least as if you go off the books. Past that, it's kind of debatable. Louisiana, somewhat, yeah, at least from the aspect of if you're not a PA, so to speak.
Policyholders, for sure.
But for policyholders, absolutely. And of course, we have our fallen king, Florida, who's just fallen down way down the list. So
Florida's a shit show right now.
Absolutely.
I don't know how much better that's going to get with the current political market that's there. They just will not investigate things. Calling you out, Florida. I'm not supposed to do that, according to people that tell me what not to say on camera. But you're really screwing this up, Florida. Colorado's a decent state too.
Colorado is a very good state. Yes.
Yeah, but so if there was a top four: Texas, Louisiana, California, Colorado.
Yeah, I could agree with all that.
All right. So high leverage states are not necessarily easier.
No, not necessarily easier.
Not necessarily easy. There might even be more work involved because there's so much more things to track.
Absolutely. So I became a PA in Georgia in 2019. And it was after I'd already been an adjuster for a few years. For those who don't know me, started at Safeco as a staff adjuster for like 5 years, 4.5. Was a contractor for like a year in Georgia and then became a PA. And looking back at my time in Georgia as a PA, there was less that I did as far as working a file back then, mainly because there wasn't much I could do to actually work that file. There weren't laws that I could cite as far as specific statutes that were violations that gave strict timelines. There wasn't penalty interest. There wasn't a Department of Insurance that frankly was at all really interested in making radical changes or holding the carrier side of the industry accountable, even at a larger scale. The legislature kind of sucks whenever it comes to insurance, consumer law. Sorry. And sorry, not sorry, whatever. And when you get to the judicial side of things, you have cases like Lamb v. Allstate, McGowan v. Progressive, et cetera, that just make Georgia the worst.
Lamb v. Allstate, we've talked about on this show several times before. It was a Georgia Supreme Court decision that decided that the words amount of loss do not include anything about scope. So from an appraisal perspective, if you and we disagree on the amount of loss, either party may demand appraisal. Well, if you have a difference of scope instead of a difference of amount of loss, then it wasn't appraisable.
Right.
They did not explain what they meant by scope, whether that was scope of repair, scope of coverages, scope of damages,
unit
mouthwash,
unit amounts, exactly.
Yeah, it didn't really explain it. So any difference of scope, and in practice, companies like State Farm, who tried this in other states as well, even without that case law, if you had a different line item on your estimate versus theirs, they would say that's a difference of scope, and it's not appraisable.
Right.
And then the state would be okay with that.
They would.
Which is the crazy part. So very low leverage. So there's all that going on in Georgia.
And in Texas, it's very different. The process here for us, whenever we work a claim at Iron Crow and even at my own firm before that, Iron Ladder, it was very much so more involved in the documentation of the claim file and holding carriers accountable via the timelines that are there under Texas statute. So, I think in Georgia, even after I left, they passed, HB 254 and a couple other bills. And one of those added finally, hey, you have to make payment within 60 days of proof of loss, or at least making a decision of coverage, I think.
So that was actually outside of legislation.
It was.
It was a regulatory change that we got them to do the year after 254, which was something that happened when I was president of GAPIA. So we directly negotiated the language of 254, which was a very anti-PA bill.
It was.
And it became a okay bill.
Yes. And so that's basically all you have. In Texas, you have a stupendous amount of timelines that you can use. And most of those are found under 542 of the Texas Insurance Code. And most of those are actually started at subchapter B. So for instance, whenever a carrier gets first notice of loss on a claim, they only have 15 calendar days to actually acknowledge that claim, to commence an investigation, to request their initial documents from the insured. They have to start all that process within no more than 15 calendar days. And then you jump down to the very next clause, which is 056. You get 15 business days to review proof of loss, and they can extend it up to 45. And you get 5 business days after a promise of payment or conditional completion for a payment to make payment. And then you have 058, which gives 60 days if no other statute applies. There's all these timelines that make it really clear on a outline basis of here's what you have to do and what you must do. And so if anything, that's actually added to our documentation, because now we're having to go through and document all these things as part of the claim. Exactly. Yeah. It's more things to track. It's more data points. So if anything, there's actually more work involved, I think, in a high leverage state, because there are more tools in the toolbox for you to use to make sure that your insured is properly indemnified, which is the main goal.
I disagree to an extent. Yes. You're absolutely right. There's definitely a lot more that has to be tracked. And you could set up processes in decent CRMs to be able to track a lot of that stuff based on which carrier it is, which form it is. You could automate a lot of this if you wanted to, depending on the capabilities of the software that you're using. Claim type hinted. So if I almost feel bad saying that because I'm actually at a Claim Wizard event. We're setting up anyway. I'm sorry, Claim
Use my
Wizard.
case,
We love
so
you
whatever.
too. You just don't pay me for my show. Anyway, in a low leverage state, to prove the loss takes more effort than in a high leverage state. But in a high leverage state, there's more things that you could win on technicality on almost. So there's a lot more things to track.
Potentially, yeah. And whenever it comes to the winning on the technicality portion of it, that's absolutely true in the sense that there are distinct things for you to hold a carrier accountable to. They're objective. They're not up to interpretation or subjective opinions, perhaps as to like whether or not they committed this thing. But whenever you have, hey, here's this thing that happened in the claim file, and after you get this thing that happens in the claim file, you get X amount of days. Well, at X plus 1, Eris, who's my math mentor, is going to love this language. Who's in the chat. When you get to X plus 1, you violated the statute. That's it, period. And you've already admitted to it. So it makes it much more distinct and easier to track in that aspect, absolutely. It gives you more tools to hold them accountable when that happens. I would say probably the one major difference whenever it comes to proving the insured's loss that is actually harder in Texas than Georgia, probably the single thing, is whenever it comes to concurrent causation. And a lot of us understand that from the aspect of two losses happening at once and who has the burden to show that segregation of damages. And Texas is somewhat unique. I think there's only 3 or 4 states, et cetera, that actually have this, that it's actually the insured's duty to segregate concurrent losses in the state of Texas. And if you fail to do that, then the loss is denied at whole for anything that you can't segregate. And in many other states, it's the exact opposite. If there's, except for anti-concurrent clause situations, et cetera, if there's 2 losses that are both, covered or not covered that affect the same area, it's going to be up to the insurance carrier to actually make that distinction or make that initial argument for segregation. And here, that's probably the one thing that becomes harder is we have to be really clear from the front end to do that.
From a technical standpoint, you're absolutely right. It is required in the state of Texas for the policyholder to perform those actions to prove that. But in practice, every state makes you do that.
True.
The carriers are denying it for wear and tear, improper installation, as if that is the proximate cause of something when in fact, it's a condition of the property that is being insured for these perils. And we've had whole discussions on wear and tear. You guys can go back. We're not going to go down a wear and tear path. We will be at this all day. There's other videos. You can go back to previous podcasts. I've got stuff on the Listen to This Full channel with it. Hell, I've even got classes on Building Experts Institute and even John Sinek and Chris Zimmerman's Master Your Craft on that. Lots of stuff on wear and tear out there. Take a look at that. Where was I going with it? Well, let me pull this question up because it's a good one and it might help us establish a little bit more what's going on. So R. Swinger asks, can you give an example of your experience where you say, man, if this was Texas, then this Georgia person would be able to do this and this and this?
Yeah, so I'm assuming, Eris, that you mean there as far as like, hey, as far as on a Georgia claim, what would make it different that same Georgia claim happened in Texas? What would they be able to do? I have a very distinct example actually on that. And Matthew may remember this one or not, where we had a claim and the carrier was just blatantly blowing through timelines, not responding, not acknowledging the loss. From the time that I assisted the insured in actually filing that claim until we got our first communication and acknowledgement back from the carrier was more than 3.5 months. And in that time period, the insured first communication back. And
even Georgia has a timeline on that.
It does. But the problem is that Georgia DOI didn't really care. I actually filed 2 back-to-back complaints, one at about 15 days, one at 30 days, where we were still getting no response. Georgia DOI came back and said, hey, we've sent it to the carrier and we're just going to wait for them to respond too. And didn't really do anything else about it. And during that time period on a water loss, the insured went ahead and started documenting everything, mitigating because they had to. Very well documented claim. And then when the carrier finally came back and actually acknowledged the claim and wanted to go inspect, the very first thing that particular carrier did, who might own autos, if y'all get the gist, is immediately say, oh, well, we weren't able to inspect prior to mitigation, so we're denying your loss outright. And that one ended up having to go to litigation. And in Texas, something like that would almost never be the case because we have that strict 15 days. And whenever it comes to those timelines, in my experience, and I know some Texas PAs are going to very wholeheartedly disagree with me, if you can show a distinct breach of those timelines in a TDI complaint or raise that specific objective issue, no opinions, just here's the facts, the TDI does tend to do something about it. It may not be a direct sanction, it may not be a direct administrative penalty or hearings, but they will give a swift kick in the butt behind the scenes to get that carrier to make contact. And I think that's something that is also very lackluster in Georgia versus Texas and would be completely different. There's just so many things.
There's a lot of things. If you were to have a claim where they were just disagreeing on whether or not something was damaged by hail or wind in Texas, you could go to appraisal on that.
Yes.
You can't do that in Georgia.
Correct. They will completely outright deny you state's coverage argument, and the courts will rarely compel them. It happened once, thanks to Stephen Bush and Trey Flornay. Shout out to them if they're watching, on a case some people in Georgia may be familiar with, which is Georgia Farm Bureau v. Moore. And they actually were able to get the court to order Georgia Farm Bureau to appraisal. And then nothing more like that happened because it kind of got wind around to everyone to not do that anymore. And in Texas, some carriers will try it. And there's explicit case law stating to the opposite. Hey, it doesn't matter if you have a coverage decision or not. It doesn't matter if coverage is affirmed or not. You still have to settle. If you had coverage, what would be the amount of loss? So you got to go. And that's a very key issue here in Texas that helps out a lot.
I find that, and one of the key distinctions that I wanted to make when we talked about this was how you were able to be more effective in Texas when you were in Georgia. You and I were friends when you were in Georgia. Now I hate you.
Yeah, it happens. A lot of people in Texas hate me.
When you were in Georgia, I remember having a conversation with you many times about how brash you were, how strong you were, maybe bulldogish would be a good term. And I didn't think that was doing you any favors in the state of Georgia. And I mentioned to you, and I almost want to take credit for it because that's how arrogant I am. I mentioned to you that you would be a really good Texas PA.
I appreciate that.
Do you remember that?
I do.
Yeah.
I do.
And then you go to Texas and you act that way and it works.
Occasionally, yes. Occasionally, yes.
Well, you have the backing of the statutes, the regulations, the case law, all that fun stuff. So talk to me about why it didn't work so much in Georgia.
The main point of it not working in Georgia really comes back to the fact that the laws themselves don't really give much teeth. I mean, for instance, on one very specific example, when it comes to bad faith, you literally have to prove the bad faith. And it even outlines, hey, these things where there might have been, a general idea that the bad faith happened, et cetera, it's not enough. And until you can prove that bad faith, there isn't the punitive damages, attorney's fees, treble damages, et cetera. There's a very, very, very strict limitation on it. The Georgia DOI, who, for all intents and purposes, at least in my opinion, has been pointless and toothless in their pursuit of taking action against carriers, even in explicitly improper situations.
I've got 3 good examples where they were good, just so you know, they are able to do good for you. So
yeah,
we don't have to go into them. I just want to say they're not completely worthless. Georgia DOI has been helpful. It's all in the way that the material is presented.
Yes. And
you have to present it. And you even teach a class on this for Texas. And yes. I think that we're not going to go into that.
Yeah.
Because we're going to do a separate video on that. But there are ways to present it. So
yes.
But it's not as clear cut in Georgia for that.
It is not. It is not. And granted, to be clear, if I handled claims in Texas the way that I did in Georgia back then, as somewhat of a, fresh off the boat, so to speak, PA, I wouldn't be as successful as I am in Texas as I am now. By no means am I driving around in my Bentley or anything like that, but I feel like I'm successful for my clients, and it's because there's been an overall change where some of that brashness that you talked about, I'm smirking because if Tom and Chase are watching and a couple other people, they're also smirking because there's been these discussions we've had lately about that and how to use that as an effective tool instead of as a blunt weapon. And I'm not, or I like to believe I'm not near as brash as I was in Georgia. I think it's something that came with time and experience to change that.
You don't have to be in Texas, you think, or you've calmed down a bit.
Both.
Yeah.
Yeah, I think coming into being a PA in Georgia.
You know what? That's actually a good point. A lot of PAs, when they first start out, they feel like their job is to fight.
Right.
And eventually they realize, maybe because they're just so freaking stressed out at some point, they break and they're like, I don't give a shit anymore. And it calms them down. But when they care that much about a file, it will eat them alive. Maybe that's what was going on. You've had so much time under your belt at that point that you understood a little bit more of how to deal with it, so you would automatically calm down.
Yes.
Is that what you think happened?
I think so. I think it came one with experience. I came into being a PA and left the
You hear that,
side.
Jack? Experience matters.
That's a good one. That was a good tie-in. The issue I think I initially had coming into being a PA in Georgia is that I was coming directly almost out of being on the carrier side. And the entire reason I left the carrier side was Harvey. There's lots of issues there. It's a whole rabbit hole we could go down. But there were improper things that happened. I saw it as like this massive injustice. And I saw it as my personal mission to have to go solve this injustice on every single claim. And so I came into it somewhat brashly. Conversation I had with an attorney I respect very much so very recently said that I would tend to steamroll the opponents out of the gate. And that is not inaccurate. I still do it at times when necessary, but I try not to do it from the very beginning of the claim. And I think that's a huge difference too, is that, like you said, partially it's because I don't really need to in Texas. You don't have to come in hard and fast in order to try to get a result all the time. I think it's useful to do it at times to show, hey, like, we know we can hold you accountable. We know what we're talking about, to show that knowledge and experience. But I think equally as important, and something that I'm honestly still striving towards and still learning and improving upon, is not just having the knowledge and being able to use it. It's being able to do so while also having a reputation for being reasonable and fair while doing so. And not just coming out as like hey, I'm, Pistol Pete over here just shooting you with statutes all the time. Being able to balance those two things, I think, is really important, where people respect you, not out of, hey, some fear of you're going to hold them accountable, but because they know your knowledge base is there. And while you can't hold them accountable, you're going to give them a chance to do the right thing too. And I did not do that in Georgia. I came out the gate, the instant they made a small mistake, boom, hit them hard, right? And I try to be a little more ease into it in Texas. And Texas allows me to do that, honestly. In Georgia, I felt like I had to, because I felt like if I didn't hold them accountable now, it's not like there's anything later to really hold them accountable to, right? In Texas, that's really not the case. I can let them make their mistakes, because their mistakes they can be held accountable for, because there's distinct statutes for it.
You and I took a completely different approach on that. That's actually really interesting. So my take on Georgia wasn't that I had to push back because there wasn't anything down the road. I felt like because there wasn't anything really backing me, that I had to work with them more.
Yeah.
And so you were attacking it head on. I knew that wasn't going to do anything from experience. So I would find ways to use what they're saying and still find the coverage, work with them in different ways. And that is what allowed my company to be as successful as we were, I believe. There's other things, but that approach, I remember many times when we heard about what our reputation was, what the insurance company had on file for us. And it was often, I remember one very specifically. It was Geico before they got bought.
Yeah.
And the guy from Geico, who's a public adjuster now, by the way, he came out and he said, I'm going to buy this roof, before he even got on it. I was like, well, he's like, I read your file and it says that you're the only honest PA in Georgia, which is crazy, right? So obviously that wasn't true. Obviously. Yeah. There's other honest PAs in Georgia. That's what I meant by that.
Yeah, exactly.
Just to be completely clear. It was a really shitty one to do that on, by the way, because right after he said that, I had to tell him, Tom would like this, I had to eat crow. I had to tell him, well, maybe you want to retract that statement because there's almost no damage on this roof.
Yeah.
You ended up buying it anyway. There was some. You sure about that? You sure about that? You sure about that? So anyway, it was pretty funny. But there was plenty of examples like that. I mean, a lot of PAs have stories like that. It definitely wasn't a unique thing, but every insurance company has record of that kind of thing. And if you're in a state, you're working in that state almost exclusively, your reputation matters a lot.
Yes.
I don't care what state you're in.
Yes.
So, but on a side note, we're going to go down a dark hole right now.
Oh man.
There are PAs that are just dicks.
Oh, 100%.
And they are still effective.
Yes.
How is that possible?
I think to some degree it's because those particular PAs who are brash for no other purpose than being brash. Like they're brash because they're arrogant. Does that make sense? Like they're condescending not because they're using it or using language in order to set up something for later in the claim file, but they're doing it as specifically a poke personally at the other party. I think sometimes some of those PAs are successful for a few reasons. One, I think it's because the type of claims they take on wouldn't get much pushback in the first place. And two, I think it's because while it appears to be successful on the front end, there's always other things happening on the backside that maybe carrier defense counsel or other people are building things on the backside. Mm-hmm. I think it also comes down to be blunt, how dickish are they being? I mean, to be honest, like we work in an industry that we know is adversarial in nature, right? And at this point, even from my time whenever I was an adjuster, it's completely different on the carrier side, where it used to be when I was a carrier adjuster, out of my team of say 10 people that were on my national catastrophe team, there was like one dude who we all knew was like a dick to everybody. And now I kind of feel like that everyone expects each other to act that way. So it somewhat becomes more adversarial than it needs to be.
Right off the bat, because they're expecting you to be that way to them. They are automatically defensive.
Yes, exactly. There's automatically a chip on the shoulder. And now it becomes this snowball down the hill, right?
No, that's true. Man, when I was a young PA, it was often that an adjuster that would meet would be like, you're the first PA I've ever met. And now that almost all of them have met a PA or have heard of a PA, I've had to explain to a lot of adjusters early in my career what a public adjuster was.
I did the same thing, yeah.
And it was so much easier back then because once they found out what you were, there was a respect level.
Yeah.
And you didn't have to, there could be mutual respect right out the gate. And now you have to overcome that. You almost have to break the ice differently because they know you're a public adjuster. They're expecting you to be a bulldog because so many dickish PAs have been that.
Yes.
To enough people that there is a reputation for it. And yet they have that chip on their shoulder.
Yes. And sometimes that can snowball.
They can.
Yeah. And other times what it can also do is that it can make it so that things are read and interpreted through rose-colored glasses, so to speak, or through a certain perspective that isn't really intended. So for instance, I had a claim recently, Tom and Chase couldn't know exactly which one I'm talking about, where all I was trying to do was lay out some various statutes and various timelines that had been breached by the carrier already. And I was like, hey, you need to be aware of these things. They're coming up. There's an encroaching deadline. And we even make it to the point where we're giving like ahead notices to the carriers. Hey, we're trying to give you every chance to do this right. And the guy had an extreme chip on his shoulder and took it very defensively, as if we were like attacking his knowledge base, as if he didn't already know these things. And by no means was it meant to be that. It was meant to be like, hey, look, we're providing clear documentation of these notices. We're making sure you're aware of them. We're all busy. And it got taken completely differently than what was intended. And especially on my side, because as anyone who knows me knows, I'm extremely analytical, direct, logical, factual, et cetera, in how I communicate. And so that can sometimes come across as cold. And what's meant to be factual can be seen as personal. And so I run into that sometimes too, where I'm having to overcome that stigma that's already there because they're already expecting me to be a cold, heartless, machine. Yeah. And yeah, sure. That too. And I'm having to overcome it, but at the same time, I'm trying to overcome that while also very clearly and specifically outlining the facts of what's gone wrong in the file or what needs to change in the file. And those sometimes conflict.
You and I are very much the same in that regard, very technical, driven. I've had PAs in my firm that were not. That would actually be an interesting topic to have on the show at some point, is the difference between a technical PA and a relationship PA,
Yes.
and having to bridge that gap a lot of times. But being a very technical minded person myself, just like you,
Yes,
it is hard not to come off as condescending.
it is.
And it's been.
How do you
it's
tell
been a
someone they're
struggle.
wrong without seeming like you're insulting them by telling them they're wrong?
So you give them all this buffer language up front. He's like, listen, I don't want to come off as condescending. I know that sometimes I do.
Yes.
I need to explain something to you. So you try to preempt it with as much language as possible.
I guarantee you Tom's laughing right now.
I bet he
knows
is.
I'm doing this.
I was on a
all the
roof.
time.
I tell this story fairly often, so you might have heard this story before, but I was on a roof after Hurricane Michael, and the adjuster and I were doing a repairability test on this shingle. And he said that it passed. And I got real close to it. I was like, well, no, here's what's going on here, 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 and here. I was like, when you lift it like that, you can clearly see. And I was coming off as condescending.
Yeah.
Completely unintentional.
Yeah.
I was just trying to have a conversation with him, but the analytical minds, we just
Yeah.
were zoned in. This guy, and you guys have to excuse my language, he's like, fuck you, man. What condescending motherfucker. It just stormed off on me, like got all up to big and everything. And I remember thinking, oh shit, did I come off as condescending again? And I could have had an argument with him at that moment, and said that he's wrong about this. I could have doubled down on it. This guy was basically stepping up to me, calling me an MFer. And instead, I swallowed my pride and I said, I'm really sorry. Sometimes I come off as condescending without meaning to. I'm very technical minded. This very same conversation with the guy. I don't mean, I know that sometimes I do. I really didn't mean to. I'm trying to point something out. I'm sorry I came off that way. It wasn't intentional.
Yeah.
And he looks at me incredulous.
Yeah.
And he goes, fuck. And he turns around and he walks away again.
Yeah.
And then he turns back. He's like, all right, I'm buying the roof. And that was the end of that. And we became friends. And I met him on several more claims, and we laughed about it. But
I mean, I've similar. Yeah. And I mean, I've had a dichotomy of experiences there, because I mean, I had a claim recently, probably in the last 6 months or so, where an adjuster was just acting inappropriately, providing improper notice of extension to their investigation, like just breaching everything he possibly could and arguing with us about it. It had already breached the proof of loss period, et cetera. And I was kind of holding him accountable to it. And I was like, hey man, like we want to, investigate this with you, inspect it, but like we need to do it this way. We need to have these things secured, et cetera. Trying to lay it out to him. I was honestly not trying to be a dick. And I remember he just showed up at my client's house without telling us and told us, you need to be here. I'm here. And I'm like, man, that's not going to happen. You're not going to dictate to me, like, we have to be there now. We just have to drop everything and come because you didn't schedule it. And he was like, man, you're such a dick. And I was like, what? Did you just say that to me? Like, you already know we record our phone calls. So like, you're just saying this to me? And he's like, whatever. And he hangs up the phone with me. Right. And that guy ended up getting removed, sent it to the manager. I was like, look, man, like, this is kind of dumb that we're at this point. We shouldn't be doing this. And then I had a completely different experience where very, very recently, where an adjuster came in and I did exactly what you're just talking about. I came across condescending without meaning to. We were in a conversation. It was a loss that clearly should have gone to large loss, and it wasn't. And when the adjuster called me back with a very bad position, and he straight up admitted to me on the phone call at the beginning, like, I've never seen an estimate like this. And like from our SPOL, like, it's very well written. It's great documentation. Never seen someone submit this, and which are all high compliments.
Yeah, especially about an estimate. Holy cow.
Yeah, like the estimate, like our proof of loss package sometimes hundreds of pages long. And so it's like this very detailed layout narrative. And and so I was, I appreciate that. And I asked him what I now look back on as obviously the cardinal sin here that everybody hates being asked, is like, how long have you been doing this for? Because it comes across as like, well, I know more than you. And when I meant it as like, he said he had never seen something like this. So I was just honestly curious, like, how long have you been doing this for? And I knew, hey, at that care, you have to be this long to be a large loss adjuster. So clearly you're probably not large loss, which is where this needs to go, because it's like 5 times over your internal limit for it, right? Like, you're saying you haven't seen this before. I appreciate that. perhaps maybe we can get it to large loss so it can be, handled per your guidelines and it gets it off your desk anyways, right? It gets a claim off your desk. That's where I was intending to go with it. And because I was honestly just curious. And he launched into a tirade about how that was personal and it didn't matter and screw me, that's this. And I did exactly what you did. And I was like, hey man, look, I want to be clear. Like, I wasn't trying to be personal. That was meant to be like a professional question of I'm just curious how long you've worked at Allstate. And here's why. And I laid it out just like that. I know this is their internal limit. I know you can't be large loss unless you've had this many years, so I'm just trying to figure that out so that we can get it a large loss, because you said you haven't seen a loss like this before. And then, hey, it gets it off your desk anyways, like, et cetera, right? Clear something out of your diary report. And whenever we had that conversation, we started discussing back and forth the facts of the claim, yada, yada, for another like 20 minutes. Anybody who's like, you know what? At the very end of the phone call, he's like, you know what? I don't fully understand everything that we just talked about. I'm going to be honest on that. But I trust that you do know what you're talking about. So I'm going to go to my manager and I'm going to explain that to him and why it should either go to large loss or maybe we should do another inspection with a different adjuster and maybe even hire a billing consultant and try to get this settled out. And it turned into this great, reasonable conversation, right? From what was initially very hostile conversation. And it's that dichotomy because I think he had a chip on his shoulder, me being his PA, right? And obviously I asked what was a very dumb question at the time, right? It should have been obvious to me that was going to be insulting, even though I didn't intend it for it to be. And on the flip side, you also have people who, because of that chip, just act completely irrationally, showing up unannounced at the insured's home as some brash maneuver of, I have the authority, whatever, and then calling you a dick when you call them out for it. And I think there's a dichotomy there that we as PAs have to overcome when we're talking about low leverage versus high leverage states.
There is. You reminded me of something that almost defined the way that I interacted with adjusters at some point. If you're an IA and you're watching this, I want you to hear this story. This will help you in dealing with PAs. There was a brand new IA that I met with on site one day. We were friendly with each other to begin with, but we were cordial to each other. Yeah. We got up on the roof. I showed him everything. He didn't fight me on anything, but he was kind of quiet.
Yeah.
It was cordial. Everything seemed to be going okay. And then he wanted to talk to the policyholder directly. And so I got the policyholder and we're standing there, the three of us. And he starts to tell the policyholder why he wasn't going to approve certain things about the roof.
Sounds familiar.
And I'm standing right there and he's saying all these things. And I'm trying to basically move this conversation to be me and the adjuster separately, not in front of the policyholder, to figure this out. Because if we're about to get into it, the last thing you want to do is get into it in front of a policyholder.
Exactly.
That guy's job could be on the line if it's done poorly in front of this policyholder. I don't want to do that. So I'm like, these are things that we definitely still probably need to talk about. I'm saying, we'll have this conversation in a little bit and really get into this. And he's like, well, no, this is the way it's going to be. And he's saying these things. Oh, and I'm looking at him like my eyes are trying to tell this guy, stop. We have to have this conversation away from this or it's not going to be good. And he kept pushing that this is it, final. He was probably nervous about meeting a PA. He was new.
Trying to assert his authority.
I have to save face in front of the policyholder.
Right.
They expect me to do my job when bullshit happens. I got to deal with that shit.
Right.
So you could clearly see that moment where it's like, all right, I guess this is what we're going to do. And I tore him a new asshole. For it. Yeah, I mean, I tried.
Yeah.
Truly tried. And I tore him a new asshole. I don't remember what it was about at all. I just remember that I clearly made that situation into everything that you said was wrong. Here's why. And it's clear and obvious. And we just did that in front of the policyholder. And it made him look really bad. And eventually at the end of that, he's like, I'll talk to my manager. And he walked away. And I told the policyholder, I was like, I'm really sorry that happened in front of you. I need to go talk to this guy. Right. He's trying to jump in his car. And I stopped him. I was like, hey, man, wait, before you go. He's just seething. I was like, dude, between you and me, that didn't have to happen. If I meet you again on site, you and I can go have a conversation that's very cordial,
Yes.
away from the policyholder. We can work together to come to an agreement. That didn't have to happen. I tried really hard not to have that conversation in front of
Yes.
her, but you kept doing this. You kept pushing it to where it had to happen right then and there. I was like, we could work together. I didn't want to do that, but I had to save face in front of my policyholder. They expect me to do this.
Yes.
And you put me in a position where I had to in order to maintain my client. So I want you to understand my motivation in that wasn't to be a dick. It was to make sure that I was doing my job when you put me on the spot to do my job in front of the policyholder.
Exactly.
My recommendation to you in the future is to try to have that conversation with a public adjuster or even contractor away from the policyholder first and see if there's anything that you can do. And I got past this barrier.
Yeah.
I was like, okay. And the next time I saw him, which was maybe a week later, he was fantastic. Thank you so much for telling me. He said that's the next time. Thank you so much for pulling me aside and saying that. That helped me out a lot. If you're an IA and you just heard that story, I want you to really take that to heart. PAs have their own motivations. We try to figure out what your motivations are.
Right.
And we try to work within there. We know that your hands are tied on things. We know all that.
Yes.
We will work with you to give you everything that you need in order to untie your hands or find some way of getting things approved so that it can get paid well enough without having to have those specific line items you're not allowed to have, whatever it might be.
Right.
We'll work with you. The vast majority of us are actually decent people trying to just do what's right by the policyholder. You're in a pickle, stuck between a rock and a hard place.
Right.
We get it. We'll work with you as long as you don't put us in a position where we have to work against you.
I think that's really important when we talk about stories like that, when we talk about low leverage versus high leverage. And I know it seems like maybe we've gone down a little fork in the road rabbit hole, but honestly, it circles back to itself. And I think here's the thing that I would take away from working in a low leverage state versus a high leverage state when it comes to statutes, laws, etc., is that I would encourage everyone on both sides to do that. So, and what I mean by that is that if you have only worked in a state like Texas ever, I would encourage you to attempt to work in a lower leverage state because I think it will improve your skill set. And if you've worked in a low leverage state, I would encourage you to work in a higher leverage state, not because it's easier, but because I think it will also develop your skill set because you realize there's more tools in the box if they're put out there that you can use than this one strategy, this one way of doing things. And I think I've run into that a lot. There's even like one particular PA that actually is currently in Georgia that I've talked to a few times still. And I see a lot of myself in the way that he handles claims because it's almost like,
I know who you're talking about.
Yeah, it's almost like blinders, so to speak. Not in the sense that he doesn't know what he's doing or that he's incapable or incompetent or anything like that.
If it's the same guy, very smart individual.
Exactly. Very smart, very high intelligence. He's very intuitive and he cares. And this particular PA, it's just that because he's only seeing the responses in this way, in this low leverage state, he's trying to work some way within the system, but also around the system to try to get the proper result for his client. And so it's almost shoehorning down a specific and single path of, here's my toolbox, open it up, it's empty except for this hammer, or it's empty except for this one tool, right? And
when you left Georgia, did you have the opinion that because you were somewhat successful in Georgia, and you were, did you think that you would be able to go into any other state and just kill it?
No.
You didn't have that opinion?
Honestly, when I moved to Texas, I actually wasn't originally moving to Texas intending to start an entirely new PA firm. It's a whole nother story. But I was actually originally coming to Texas to work with several people, and I was mainly going to try to actually help others PA. So like estimating and essentially consulting almost from behind the scenes for them and assisting them, writing arguments, etc. Was my plan. And that did not work out for various reasons with that specific party I was trying to work with. But I ended up on my own. And for the longest time, I felt like I had more tools at my disposal, and I researched a lot of the statutes. And I loved it, but by no means did I think that I was automatically going to come to Texas. And hey, I've gone through the trial by fire, which is the way many PAs reference Georgia once they've worked there. Is that it is the trial by fire, so to speak.
It's basically boot camp.
Exactly, it is.
Yeah.
It is the boot camp. Hi, Cal Spoo. It's the whatever jokes. It's the it's the boot camp for PA, so to speak, in the sense of like a statutory environment for you to have to work through to understand where you were limiting yourself because you were only trying to react to the things you were given. Georgia's a very reactionary state. There's not much you can do on your side to make the carriers react to what you're doing. And in Texas, it's very different because you're not really having to make them react to you. You're just having to make them react to you holding them accountable to the statutes and tools you have available to you. And I think
that is a big distinction.
Yeah. And
I like that.
Yeah. And I think it's really important because to kind of circle back to my point is that when you've worked in a high leverage state, I've come across several PAs. I'm trying to say this in a politically correct way, so to speak. I don't want to be condescending, right? I'm not trying to be a dick. Some PAs, I'm just going to say it bluntly, just knowing I'm not trying to be a dick, okay? Humor. Some PAs are lazy. They're lazy.
No.
They come in and they are glorified. Sorry, Chase. They're glorified supplementers. By no means an offense to supplementers, but in the sense that they're coming in to do the same tasks that supplementers can do, but they don't actually advocate for the client beyond that because in some cases they don't need to.
A lot of those are just ex-roofers that became a PA.
Yeah, ex-roofers,
so they do the same job thinking that the license is going to make the difference, but they don't actually learn how to be a PA.
Right.
They're still just a supplementer with a
That was me in Georgia. I went from...
Oh, really?
Oh, 100%. I went from staff adjuster to contractor, thinking that would help me build up my network and connections. And then I got the PA license, and I realized after moving to Texas and looking back that I basically did that. I was acting as the contractor because at that point in time you could be both at the same time in Georgia. And
don't recommend it.
No,
even if it's allowed.
Yeah, even if it's allowed. That was not
talking to you, part. Chicago.
Oh man, Illinois is going to jump into the chat. F of the chat. So in any case, like I look back on that and I think I was doing a lot of that. I was doing a lot of, hey, if I simply talk to him about these things, because I have a PA license, it's going to give me more credential or authority. And that was completely the wrong way to do it. Because what I needed to be doing is as a PA, properly documenting and advocating for my client. And I think working in a high leverage state like Texas taught me how to do that better because I had more ability to document the things I needed to. And so I went from my version of a proof of loss in Georgia was the statement of loss sheet with what was at the time given to me language from Stephen Bush's disclaimer that he put on there that I still use a version of, and the estimate and some photos. That was my proof of loss. And I would send it in. And sometimes it would be notarized, and sometimes it wouldn't be, and sometimes it'd be sworn, and sometimes it wouldn't be. And you know, I was very inconsistent. I'm gonna be honest.
I bet I was rejected every time.
You know what's funny though is that it wasn't. It was only rejected like twice ever, and that astounds me because now I'm here in Texas, and Tom and Chase are just cracking up in the background. I guarantee if they're watching this, because now we have these very well thought out and established, very much different than even the version I sent you. Proof of loss packets that lay out, hey, here's what's happened in the file. Here's what we need you to do. And here's why. Here's the coverage that shows you this is why this is covered in your policy. And here's all the documentation to prove that coverage. And it's perfectly by statute and by contract, even lays out how it fills out the contract. Dadgummit, if more documentation doesn't result in more carriers rejecting them off the bat anyways. But I feel like I do a better job.
At that point.
They have to at that point.
Oh, shit.
The light died.
Keep talking.
Yeah, no, you're good. I feel like that, you know, it's become dark and moody, guys. It's a great atmosphere. So I feel like that's actually made me better as a PA, and I would encourage other PAs to take advantage of that. If you work in a state like Georgia, I would say Arizona is similar because they have similar appraisal case law, if I remember.
I think we're just going to be dark. I can't find the shower cable.
I set it down for you somewhere. In any case, yeah, there you go. So I would encourage you to do that because I think it'll make you a better PA. It's absolutely made me a better PA. There are so many times, And I'll make an analogy. I think we all as adults at some point are sitting there taking a shower. I hope everybody else does this too, and it's not just me being weird. You're taking a shower. It's not going down a path I promise you think it is, guys.
It's gonna be weird.
It's gonna be weird. Everything with me is weird. So where you're like taking a shower and suddenly like that memory from 3rd grade where you did something super strange or weird in class and cringing, you're like, ugh, and it hits you. I look at that sometimes as the way I look back at how I handle claims in Georgia, where I would handle claims in Georgia very differently. I still think I would be more successful in Texas than I would be in Georgia even now because of the ability to hold carriers accountable, like with the TDI complaint I filed with State Farm, right? And for those of you who don't know, I'm going to pat myself on the back for a moment. Hope you don't mind, whatever. But right after coming into Texas, one of the first things I did is I looked at the statutes like, hey, I have more ability to hold the carrier accountable. I'm going to file a TDI complaint and try my luck. And it was one of my very first ones. And it was about State Farm underpaying interest and paying the improper percentage of interest on claims. And State Farm disagreed with me. It was only like $800 that they underpay my client, and I filed a complaint. And over the next year and a half, I had hours of conversation with someone in enforcement at TDI, and that ended in a disciplinary order. And it came out almost exactly a year ago, March 10th of 2023. It came out actually, where State Farm ended up having to pay over $800 in missed interest on a complaint, $1.75 million between administrative penalties and restitution.
Just in penalties and restitution.
Just in penalties. It was like $350,000 in administrative penalties and about 1.4 million restitution, over $800, and I made $80 off that. That was nice.
Let me ask you. Yes. I don't remember the question now.
Mm-hmm.
You said more stuff. Is there we talked about having technical PAs and more like relationship PAs. We didn't really give examples other than the fact that we're both technical PAs. Do you think a technical PA is better off in a high leverage state, and maybe the opposite, a more relationship PA might be better off in a lower leverage state?
I think yes, but with the caveat that I think it would be good for our industry as a whole, for those people who consider themselves technical PAs, and pot, meat, kettle, to find a way to make themselves more of a relationship PA, and for relationship PAs to do the same thing and make themselves more technical, because I think that's where you truly have success.
That's how you grow.
Yes, that's how you grow. And I'll share something that was said to me by an attorney I very much so respect, and I consider actually a very close friend. And if he's watching, I hope he hears this. But
you're going to say his name after all that glory? Like
Trey Flournoy. Hi. So I'll just go ahead and say it. That's fine.
I know him.
You will meet him tonight. Fantastic attorney, originally with Bush, now with Maryland Law Group. Love the guy to death. He is one of the best litigators I've ever come across. And we had a conversation recently actually about this exact topic, and due to a claim file that came up and how it was handled and the outcome of it, et cetera, and where we can improve, just kind of looking back and reflecting on it. And what he said to me was this. He said that I'm already speaking to myself, not trying to inflate my own ego, just quoting back what Trey said. So if you disagree, make a problem with Trey, not me. So he said, you're already formidable when it comes to knowledge. If you and I were to both take tests about statutes in Texas, you would pass. You would absolutely destroy me, and maybe even in Florida, and you don't even work there. But he's like, the difference is, right? He's like, the difference is that while you become known as that, he's like, my fear for you would be that you would become known as knowledgeable and formidable and highly technical, but ruthlessly so. And that you don't have the aspect of being known as fair and reasonable on the backside of being willing, where if someone messes up, you don't just steamroll them and destroy them because of it. And he's like, I feel like sometimes there's a Venn diagram between being reasonable and fair, or holding them accountable, et cetera, or giving them some mercy whenever they make a mistake. The sliver in between where you're kind of trying to do that is really narrow. And he's like, I would encourage you to widen that margin of your skill set, to make it where there's not so much a dichotomy between I'm ruthless or I'm reasonable, but you can kind of intermix both, where you can be highly technical and reasonable at the same time. And I think that would be good for all PAs.
earlier you said that you think that a low leverage state person should try a high leverage state. Do you think that that is what would push them to change slightly?
Hopefully.
Or
So.
is that just another thing for them to grow on and change how they approach things? And I wanted to say this because I asked you the question, and I want to be fair. I was arrogant enough to believe that because I was successful in Georgia, that I could go into any state and be successful. And then I found out the hard way that that was wrong.
Yeah.
Because Florida kicked my ass.
Oh yeah.
It's just different. They're all different. And you have to approach things differently. You can't have the same strategies. You can't have the same approach in a different state. They're all different. The laws are different. Everything's different.
Yes.
Don't assume.
Yeah. And even states that can be very similar can end up being different whenever you look at them on the books. Like Colorado and Texas aren't overly different as to, hey, they both have some kind of way to hold the carrier accountable, but they both have statutory penalties. They both have very similar unfair claim settlement practices acts. They both have very similar statutory provisions when it comes to attorney's fees and things like that. Not nearly the same, but similar in nature, and yet they're completely different environments, honestly, as a PA. Or when you're handling claims, there's attorneys or anything like that. I think that's a really key point. And so to come back to that question that you asked is that I think someone who transitions from either side of the spectrum from
we're on the spectrum now, guys.
I definitely am. From a high leverage state to a low leverage state or the other direction, I think it'll come down to which kind of PA are you willing to be, which kind of professional are you willing to be. There are going to be people who are in low leverage states and did what I initially did when I came to Texas at first, which is that I took that brashness and I was just empowered by it because now I actually have teeth. And the way Tom puts it sometimes is I would take people's arms off and beat them over the head with it when they made a mistake. Like, haha, you made a mistake. Now you're in trouble.
Tom is like the opposite of you. He's
to
the
some degree
relationship guy.
Somewhat.
Well, in comparison to you,
yeah.
He's glorified in that way. Because you're so technical.
Yes. I will say that I think that's where, if I'm going to...
You guys make a good partnership for that reason.
Yes, and I think that's why Chase adds so much to us as well, which is a newer...
Chase?
You have not met Chase, no, but you should tonight. I believe he's coming. And he's a third partner that we just added this year to Iron Crow. So shout out to him. And he is a almost new PA. He's only been a PA for, I say almost new, but it's almost been a year now, actually.
Yeah.
And he's almost the split difference between me and Tom. I'm very highly analytical. I don't pick up on social cues well, etc. I'm almost cold and heartless when it comes to that, to the degree of logic. And my wife is watching. She absolutely is nodding her head in agreement with all of this.
She's probably not watching.
She's probably not.
Show.
Yeah. We'll see her tonight.
So we need to actually wrap this up. So let me bring us back to just final thoughts. High leverage state versus low leverage state. If you were going to try to choose what state to work in to start off.
Low leverage state.
Low leverage state.
Low leverage state.
Cut your teeth in the low leverage, and you're going to get frustrated.
Yes.
But the high leverage state is just too much to track for a brand new person, maybe?
It's not that it's too much to track. I think it doesn't develop your skill set enough whenever it comes to resolving conflict because of that issue. I think it's almost a if you're trying to teach a kid how to swim, sometimes you got to throw them in the deep end of the pool, so to speak, or let the kid push themselves on the bike kind of deal. And if they fall, they fall. You're there to pick them up because I think in a high leverage state at times, there's certain people who will just succeed no matter where they are at, and they're great. There's some people, it's almost a handicap to them because they never learn how to have to maneuver claims with only one tool in your toolbox.
It's like the PAs in Florida right now. They're so used to being able to hand things off to an attorney. The attorney's fees will get paid. It's not a big deal. And now they don't necessarily have that for claims that are existing after Ian.
Yes.
So now they have to figure out how to work a claim without handing it off to an attorney.
Yes.
Giving it to mommy and daddy when they fail.
Oh man.
Yeah.
Oh no.
So, guys, we're gonna have to let you go because we're at this conference. I want to give you an interesting update though. This coming Monday, I'm going to be in trial for the very first time in my entire career for a claim that I was in. We had over 8,000 claims. I've been deposed 2 times, and this will be my first trial.
That's crazy.
It's insane. It makes no sense, honestly. And even in this trial, they didn't depose me. So I'm going to give you guys some updates on what that looks like, how that went. It'll be my first real experience in trial. Even as an expert, I'm an expert in a lot of files, but they never go to trial.
Yeah.
But that's another symptom of a low leverage state. Most of the stuff is in Georgia, and they almost never go to trial in Georgia. Right. And in the high leverage states, they do go to trial a hell of a lot more. And that's one thing we didn't touch on. We don't have time for it, but one of the things about high level states is there's a lot of case law.
Yes.
That's constantly coming out. You have to constantly be on top of. Georgia hasn't had case law in years.
Yeah. And we can talk about that a lot in the podcast.
Let's do that.
Let's
do that. So real quick, thank you for watching the show. If you are a public adjuster, Claim Titan is an amazing CRM. It will help you keep track of shit. But Claim Titan is not just for public adjusters anymore. It's also for appraisers and supplementers. And it's fantastic. I actually started going through some of this in order to build out a profile for brand new PAs for the PA 101 class that I do now. So we ended up finding a few different holes in the system, and I worked with Eric to fix it. So it's strong. Strong. Building Experts Institute is still there. It's an online go-to-your-own-pace school. That's my online school with Matt Danskin. BuildingExperts.institute is a website as in-depth training as you can get. We just dropped the inspection class on how to perform a wind or hail inspection on a house. And it's literally step-by-step how to perform the inspection. And then there's the classes on how to identify hail, how to identify wind, and all that kind of stuff or other separated classes. So everything is there now for a brand new person just getting into the storm market to be able to pick that up and go. They can even learn Xactimate level 1, 2, and 3 while they're in there, all for one monthly rate of $109 a month. Such a little amount that we're probably going to have to increase it at some point. You better jump in there while you can. Book Agency, if you're a roofer, is one of the best marketing firms for roofers I've ever come across. They're so damn good. They convinced me to get a tattoo at a convention, and I'm terrified of needles. You can find that video. I'm not crying in the video. I lost my voice. It's definitely not me crying, but it's there. Whatever you want to believe. The American Policyholder Association is a group of individuals that try to uncover insurance fraud and prosecute against it, but insurance fraud committed by the insurance companies. Yes. There are a lot of different things that happen on that regard. If you believe that you've got insurance fraud committed by the insurance carrier on your claim, then go to apassociation.org and fill out the form and submit it. And there are ex-FBI investigators that will take a look at that and let you know if there's a possibility that you have fraud. And if there is, they'll open a full investigation. Huggins Law Firm, Remington was not able to be here. He's in some depositions like crazy today for upcoming trial that he's got. We're just getting a lot of trials suddenly. Mm-hmm. So he wasn't able to be here, but if you are in Georgia or Florida, Remington is one of the best attorneys, and he's a really good friend of mine. So take a look at hugginslaw.com. Next Tuesday, 4 o'clock, we actually we're going to try to get back on track with podcasts. That might have just changed because I just booked a private training. These podcasts are getting harder and harder to do the more and more that my schedule fills up. I don't know what's going to happen, guys. Yeah, I might end up having to stop doing the podcast. It's a real problem. Maybe I can find someone to pick up where I left off and take over the hosting. Hey, if you're interested in that, let me know. This is the first time I've even thinking about it. I'm saying it out loud online. All right.
Doesn't say it to the guy sitting next to him. I was going to point that out.
I said it to the camera. This guy. See you guys next Tuesday. All right. Thanks for being on. Let's pretend like we're going to walk away from each other now. Bye.
Bye.